breaking and entering, drunk and disorderly, law and order. A former prosecutor and a defence barrister, not your usual pairing. And the result? Conversations about crime and punishment that are guaranteed to get you thinking.
Welcome to Justice Matters, a weekly podcast with Lizzie Green and Jay Merchant. Our episodes are every Monday on Apple Podcasts, Spotify, and YouTube. Follow us on Instagram at Justice Matters Pod for clips. Enjoy the episode. This episode deals with sexual harassment in the workplace. Discretion is advised. Good morning. Good afternoon. I don't know what it is right now, but
Well, we'll go with good afternoon.
good whatever.
Yes. How are you?
I'm good, thanks. How are you?
I'm good. I'm a little apprehensive, I think, about today's discussion.
All right. Well, I'm excited for it now that you're apprehended.
Well, yes. So I came to this topic because there was an article in the media in early July of this year, and it related to a former Northern Territory Supreme Court judge who is facing very serious allegations of sexual harassment against a former judge's associate.
Ooh.
So their own associate.
So we've got an element of power and influence and a disparity there.
That's right. So
All right.
for anyone who's not aware, every single judge has an associate
Right.
who is often maybe still a law student or newly graduated.
Yes.
That's right. Who is their right-hand person.
Yes.
You know, they do administrative
Thick and thin.
assistance, secretarial research, companionship.
Yes.
I was a judge's associate.
Oh, really?
Yes,
Oh,
for
that's
2.5 years.
I was not smart enough to be one.
Well, I was very lucky, and I still say to anyone who listens, that would be one of the best jobs I've ever had.
Oh, I bet.
And my judge was just an amazing person. He was so intelligent and knowledgeable and kind. And, you know, that time was...
Still a judge?
He's retired now.
So can we mention him?
Oh, yes, Judge Philip Nace.
Yeah, let's give him a shout out, Judge.
He was in Rockhampton and then in Beenleigh.
Okay.
And so that job took me into criminal law.
Yeah.
I learnt so much. I enjoyed every single day in that job. And then I read an article like this and it really strikes a chord with me because your judge is the only person really that you're working with. It is a very close relationship. You have to have rapport. You have to have respect.
And can I just say that the level of access that you have as an associate, nobody else has.
No.
So it is in a very privileged position
Yes.
to be an associate. Like I said, I was never at that level. But the ones that are so close to their judge in and out of court.
Yes,
And
that's right.
it's a rare access.
And you go on circuit court, so you're traveling, you know, it's all, you know. And so I look at that as one of the best things I was ever able to have done.
Yeah.
I loved that job. And so when I hear that there is a former associate who has brought these allegations of sexual harassment against their judge, I just feel so upset about that. So these are historical in a way, like they're quite dated, but they were brought first in May 2024. There was a complaint lodged with the Northern Territory Anti-Discrimination Commission. So there was also an allegation of discrimination by other judicial officers in relation to their handling of her complaint at the time.
Okay.
Okay, so they're a little dated, but
so when
recently brought to the Anti-Discrimination Commission.
So they were brought in 2024. Do we know when the allegations, like were we talking 10 years ago?
I think possibly.
Okay.
That
no, that's
time.
all right. I was just curious if it was back in the 70s or something like
No,
that.
not that.
All
not
right.
that old.
All right.
So the alleged harassment included making inappropriate comments, taking photos of her without permission, and directing her to attend social engagements with the judge outside of work hours.
Okay.
Okay.
So on the scale of conduct, I'm not.
Well, no, so probably more
I'm not
minor.
there.
But when you think about what you said, the balance of power.
Yes, okay.
And
especially if she didn't want to or didn't.
That's right.
Yeah, if she
That's
felt
right.
obligated. I'm
Yes.
trying to
Yeah.
find a way to make it work.
Yeah, she didn't want to.
All right,
and
fair
I
enough.
can say in 2.5 years, I did not accompany my judge on social occasions.
See, I would have no problem with that, I guess, but
it didn't,
different perspective.
It wasn't raised,
Yeah.
you know.
Yeah.
Anyway, so Dr. Vivian Tom, who is an Australian former public servant and a current independent consultant and intelligence specialist, has been commissioned by the Northern Territory government to investigate this complaint.
Okay.
Her report concluded the judge had sexually harassed the associate, but the Northern Territory government urged the Anti-Discrimination Commission to dismiss the complaint because they had occurred years earlier.
That's bullshit.
The Anti-Discrimination Commission rejected those arguments and accepted the complaint. That was just on June 12. And they said the complaint was very serious. So there should be some outcome in future months. But when I read that, I was immediately taken back to an earlier, very similar situation that involved retired High Court Justice Hayden Dyson.
Okay.
So that was also investigated by this same Vivian Tom.
All right.
To see if there was merit to those allegations. And so that's prompted me to talk about that case because Dyson has been back in the media recently about a textbook he's written, and I've just got a lot of feelings about all of it.
No, that's good. Well, let's get through it.
So I wanted to start
Sure.
Just about the issue of sexual harassment within the legal profession specifically.
Okay.
Like there's a lot that has been done in terms of mental health of lawyers and the toll that the judge of the job takes. One of the things that's also been investigated is this culture of sexual harassment within the legal profession.
Can I just say that more needs to be done on the mental health side of things, but let's also
100%,
focus. Yeah.
Yes.
I mean, we've lost so many great people even in this community.
Yes,
So,
I agree.
But I'm interested to hear what you have to say.
Well, so in an article written by the Law Council of Australia President Julia Warner in Lawyers Weekly, just in June of this year, she was quoted as saying, "One of our greatest challenges, the legal profession, is our track record in protecting all members of our profession from sexual harassment." In 2019, the International Bar Association released its Us Too report on bullying and sexual harassment in the legal profession, and based on survey responses, nearly 30% of lawyers in Australia have experienced sexual harassment. So there's a lot more in that article. It's worth a read.
Okay.
But the good thing is that there's recognition that this is an issue that needs to be addressed, but it made me question when I read that story about the Northern Territory judge, have we actually made enough progress is where I'm wondering.
Yeah, and I mean, if that's the highest of the high in terms of the legal profession is when we have allegations made against a judge from an associate.
That's right. So let me take you back to March 2019.
Okay.
And this was when the chief executive and principal registrar of the High Court received a phone call from a firm of solicitors alerting her to the fact she would be sent allegations of sexual harassment against former High Court Justice Dyson Hayden. There were 3 sets of allegations included in the initial correspondence, so 3 different complainants.
So this was correspondence sent to the High Court, not police?
That's right.
Okay.
The conduct that was alleged involved unwelcome touching, attempting to kiss the women and taking them into his bedroom. The alleged events date back to between 2003 and 2013 when he, one of the nation's most eminent jurors, served on the bench of the High Court until his retirement at the legal maximum age of 70.
There's so much wrong with that. I mean, a judge taking people back to the bedroom, I'm just not sure. I've got a very uneasy feeling with this.
Very, very bad.
Yeah.
And again, I just think back to the dynamic of a judge and an associate and the power imbalance is huge.
Yep.
So the Chief Justice and other justices decided to have an independent investigation into these matters.
Well, I'm glad they didn't shuffle it under the rug.
So am I. And I'm actually not surprised, but pleasantly
Yeah, I've got
relieved.
confidence.
Yes.
I mean, sunlight is the best disinfectant. Let's not hide it. Let's ventilate it.
And so Vivian Tom undertook the investigation. During the course of that investigation, she did speak to a number of people who had been in the associate system.
Yes.
But no serving justices were interviewed by her.
Why?
I don't know. And no current staff were interviewed by her. So that was something I thought was an anomaly. The final report was provided to the Chief Registrar, then forwarded to the Chief Justice, who was Susan Keifel,
Yep.
in March 2020. Now, the report has been made confidential, so I couldn't find it anywhere. But some details were reported in the media, and there was an official statement made by Justice Keifel after the report had been received by her.
Okay.
So she said, the investigation found that 6 former court staff members who were judges' associates were harassed by the former Justice Hayden. Heydon denied wrongdoing all the way through, still denies
Really? Didn't do it.
wrongdoing.
Didn't do it.
5 of the 6 associates who lodged complaints that were found to have had merit worked in his office. So Keifel had said in the media, we have made a sincere apology to the 6 women whose complaints were borne out. We know it would have been difficult to come forward. Their accounts of their experiences at the time have been believed.
Okay.
That's a massive statement.
It is. Their accounts of what transpired has been believed.
And that is still, that text of that statement is still available. I read it myself on the internet. So it's not the media misreporting.
That's right.
This is what her statement said.
And all the while, we still have deny.
Yes, absolute denials. So Tom's report found that the evidence demonstrated a tendency by Heydon to engage in a pattern of conduct of sexual harassment. 2 of the women whose allegations were upheld were Rachel Collins and Chelsea Tabart, and they were represented by Maurice Blackburn lawyers, specifically Josh Bornstein spoke out on their behalf, and he said that the investigation had unveiled a pattern of predatory behaviour and sexual harassment over many years by Heydon towards young female associates he employed, and highlighted a gap in both addressing judicial misconduct and protecting their employees from that misconduct. At the time that this sexual harassment occurred, Dyson Hayden was in his 60s, a conservative judge, a prominent Christian, and a married man. The women he employed were in their early 20s, often straight out of university. He was one of the most powerful men in the country who could make or break their future careers in the law.
And they knew that.
Yes. So he said a number of the women who were harassed abandoned their plans for a legal career after their experience of being sexually harassed. And to me, obviously, that's not the worst part, but to me, that just is a tragedy, because I think of my experience and it inspired me to go into criminal law. It inspired me to want to follow in my judge's footsteps. He was, he prosecuted, he was a defense counsel, he was an inspiration to me. And this is the complete antithesis of that experience. And I just feel so sad for them.
I'm not wondering though, this conduct had to have been more than just sending a text message. It had to be more than just harassment, in the sense of they're leaving the profession. So while we say it's sexual harassment, I mean, because that's what we have to say it is, I don't think that touches the surface of what transpired.
And so because the report is confidential, I've had to take a lot of the contextual information from media
Right.
reports. So that is a disclaimer I'm making at the
Yes.
start. But Rachel Collins was reported as saying that the judge's actions had real and terrible consequences that led her to abandon plans to become a barrister. She alleged he made repeated advances towards her, on one occasion asking if he could kiss her. He said that was because she was beautiful.
Completely
I
inappropriate.
can't
Objection.
even imagine being put in that position. Chelsea Tabart said she had left the law after her experience because the culture was broken from the top down. She also said she would not be safe from powerful men like Mr. Hayden even if I reported them. She alleged that on her first day working for him, he suggested they stop for a drink after an office dinner. He took her to a private room at a prestigious club, put his hand on her thigh. She was 22.
Yeah, that might have been a good day for her to say, I'm out of here.
But this is the thing. You get offered an opportunity like an associateship and you can see your career unfolding in front of you. You get the experience, the contacts, the cachet that comes with being an associate. Who's going to give that up because you think, oh, am I making
an
overreaction?
I guess I should also say that, perhaps at the beginning it was exciting to be in the presence of somebody of that stature and who wouldn't go for a drink with somebody despite there being a little bit of impropriety and
And you should be able to go for a drink.
Oh yeah.
But not take into a private room.
No,
that's not be touched.
That concerns me about that. That's the only reason why I say that might have been a good day for her to walk away.
But hindsight is a wonderful thing.
Yeah.
It was also reported that a current judge now, who was at that time a barrister, said that Heydon had allegedly indecently assaulted her and that he knew she was not consenting at the time. She said he slid his hand between her thighs at a professional law dinner not long after he joined the bench. She didn't complain afterwards because it could have killed the career of a female practitioner, she said.
I guess, yeah. I mean, I've never been put in a position like that, so it's easy for me to say, from my perspective, that would have been the last. But I can empathize and see why my position
Jay,
is not
the culture,
the right one.
Like, even when there is evidence of sexual assault or worse, the chance of a successful prosecution is so low. Like, people are not believed. People, this is the culture. And we're talking 10, 15 years ago now when it was even less believed and accepted, these kinds of allegations.
Yeah. Can I just say that since I was admitted back in 2012, I can honestly say I haven't seen anything. But again, I'm not at that level of the judges and the associates and stuff.
And you're not the target victim.
No, they don't. Nobody wants me.
I don't mean that. I mean, your gender is the thing that rules you out. Heydon is also alleged, according to reports after the inquiry, to have indecently assaulted the then president of the ACT Law Society, Noel Bloomer, at the University of Canberra Ball in April 2013. He was allegedly removed from the event and returned to his accommodation after a complaint was made on the night. So
the complaint made on the night, why wasn't something done with it? Who was it made to?
It was made to the university. So she said she reported Heydon started feeling up the side of my leg at the dinner. On the pretext of discussing adoption law with her, he allegedly took her to an empty room where he attempted to forcibly kiss her. In a contemporaneous note made at the time, she said she complained about him to other people and to the University of Canberra, and the university confirmed the complaint was received.
Well, that's great that the complaint was received. Congratulations for receiving that. But what do you do with it?
I know. So Heydon, via his lawyers, denied emphatically any allegation of sexual harassment or any offence. In respect of the confidential inquiry and its subsequent confidential report, any allegation of predatory behaviour or breaches of the law is categorically denied by our client, a statement from his lawyers said. Our client says that if any conduct of his has caused offence, that result was inadvertent and unintended, and he apologises for any offence caused. We have asked the High Court to convey that directly to the associate complainants.
But isn't that the same message that we see with contemporaneous stars when there's allegations? They say, oh, if your interpretation of what transpired offended you, I'm sorry.
That's right. Then his lawyers said, the inquiry was not an internal administrative inquiry and was conducted by a public servant and not by a lawyer, judge, or a tribunal member. It was conducted without having statutory powers of investigation and of administering affirmations or oaths. So that obviously made it invalid.
Well, yeah, I mean, yeah. It's
Commissioned
like
by
it
the High
didn't
Court.
happen.
Commissioned by the High Court,
Yeah.
but had no real value, according to his
All
lawyers.
right. So what are we supposed to do then? Have a government
inquiry,
a royal commission into the conduct? Is that, I mean, certainly, I mean, the reason why they say that is the oath or affirmation component of it. But at the same token, it's the versions of events in the conduct of an investigation.
That Chief Justice,
yes, well, the High
said
Court,
they were believed.
yes.
So, I mean, the weight of that statement. So the Commonwealth reached an historic financial settlement with 3 of the women who were found to have been sexually harassed by former High Court Judge Dyson
So the
Hayden.
Commonwealth, the taxpayers are fitting the bill.
Yes, not Heydon.
All right.
Yep. The Attorney General at the time, Michaela Cash, announced the compensation payout in 2022, along with an apology to the 3 women. And all of them signed a non-disclosure agreement as part of the settlement.
Yeah, and that's part and parcel with
which
those.
is fine.
That's what
nobody needs to know what the compensation was, but the fact that it was an historic settlement is significant. That gives, again, weight and credence to. And you know what it reminds me of? And I'm going to get distracted here, but George Pell, which I have a lot of issues with, that whole situation. But so he's ended up being found innocent. You know, he was acquitted on appeal. But the church paid compensation to his victims. And I'm like, well, how do you reconcile that, you know?
And I think a lot of people are thinking the same thing as you on that front, too.
And so to me, this is interesting. But so there were no criminal charges laid. Let me be very clear. There was an article from June 2020, 2 months after the report was finalised, that said that the ACT's DPP had referred the matter to the Australian Federal Police, recommending they investigate Heydon in the wake of the independent inquiry. That Shane Drumgold, Senior Counsel, told the media he had written to the AFP immediately, alerting police to the findings. Such an investigation would be conducted by the ACT Police, the AFP's local arm. So that sounded positive. But despite the AFP seeking a copy of the independent report, the High Court has not provided it to them because it's confidential.
Can they not issue it? Oh.
The court's chief executive and principal registrar has instead advised that the 6 women could individually elect to provide the police with the section of the report relating to their own experiences.
But I don't know if they could because there was a non-disclosure agreement and I don't know the terms of that agreement. So it could be the case that they are barred.
I don't know. Federal Attorney General Christian Porter, a familiar name, said the investigation was a matter for the High Court to deal with. He said the High Court is entirely independent of executive government, which independence extends to the management and response to matters such as this. I have been made aware as a courtesy by the court of the issue and how it is being managed. So I'm not sure if he was referring to the harassment claims there or to potential prosecution for sexual charges. That wasn't clear. But I should note he faced his own allegations of rape in 2021. That complainant had taken her own life, sadly, and so the matter didn't proceed. But as far as I can see, there has been no further action there.
I just want to touch base on what he said about independence because they're talking about the separation of powers stuff. And we see a lot of it in parliamentary privilege where the speaker does have the power to discipline its own members and stuff. I've never actually seen an analogous argument quite like this in terms of the courts. I know there's judicial immunity when they're acting in accordance with their role. But when they themselves go on a frolic of their own.
Yeah, I don't see how it can't just be a normal criminal prosecution, notwithstanding the fact that he's a judge.
Yeah, no.
Like it shouldn't have any bearing there.
That's right. Because even the Vasta decision, it was in the course of the role and the duties.
Yep.
The going back to a hotel room after and the putting the hand on the knees or wherever he put the hands is on that frolic.
So, no criminal charges. So, were there any other consequences? Because he didn't pay compensation.
No,
the allegations weren't made until after he had retired from the High Court. So, he couldn't be, removed from the bench.
No, that's right.
But so he had gone back to the bar to practice after he left the High Court.
Yep.
And his name was stripped from the website of 8th Floor Selborne Chambers, where he had been listed since returning in 2015. The PM at the time, Scott Morrison, described the allegations against him as incredibly serious and very disturbing and concerning. He said the question of stripping the former judge of his AC commendation would be considered at a later time. Scott Morrison said, people's awards and honours, if those processes end in a place where people have, where those allegations have been upheld, then there's a normal process for honours to be dealt with at that time. So he flagged that he would consider that. However, in November 2022, it was reported that Heydon himself had surrendered his status as a Companion of the Order of Australia. His decision to relinquish the honour granted was announced in the Government Gazette, released in that month. So he wasn't stripped of it, he relinquished it.
Well, and if we can read the writing on the wall, I'm assuming that he was tapped on the shoulder and said, hey, if you don't relinquish it, we're going to strip it. Maybe,
I think
perhaps.
I would have liked it if he'd been stripped.
Yeah, but keep in mind, though, I mean, I accept, as the High Court Chief Justice did, that the allegations were believed, but at the same token, he was not found by a court or tribunal
guilty of anything.
No,
that's true.
So let's keep that in mind.
Yes.
And that's both beyond reasonable doubt and on balance.
That's right. I understand that. And that's why I think I am a little wary discussing all of this, because there are no convictions but the culture, this is so indicative of what is problematic.
Yeah, and it's not just in the legal fraternity. I mean, it's in Parliament as well. You talked about the former Minister Porter there.
Yep.
And
absolutely.
What's transpired in Canberra the last couple of years.
What else? So he maintains his honourable title, but he has allowed his legal practicing licence to lapse. In 2020, the University of Sydney claimed to be reviewing its association with Heydon, who is an emeritus professor there. A spokeswoman from the university at that time, 2020, said, Professor Heydon was last employed by the university in 1981. He has no ongoing employment relationship with us. As is the case with many retired members of staff, he was appointed an emeritus professor some time ago. It is not an employment relationship and does not involve any remuneration. The university's law school dean, Professor Simon Bronnett, expressed solidarity and support for the women who came forward. He said, I wish to commend the courage of our alumna, Chelsea Tabat, one of our best and brightest students, and other female associates in righting these wrongs. They no longer need suffer in silence. However, I did a little search of USyd's emeritus professors, and he's still listed there.
Yeah. The message from the dean in righting these wrongs, or whatever you said too, I'm not sure they have been righted.
Me either.
So
there was some comment by the legal fraternity at the time. The president of the New South Wales Bar Association, Tim Game SC, said the publication of the High Court's findings was a singular event for the sector, and that disrespectful behaviour towards women had no place at the New South Wales Bar. He said that we also have to think about the particular vulnerabilities of judges' associates, which is something we've talked about. Most of Heydon's contemporaries at the High Court have declined to comment.
Which is appropriate.
Yeah, that's fine. Justice French, who was Chief Justice from 2008 to 2017 and is now Chancellor of the University of Western Australia, told The Australian he had not been aware of any concerns about Heydon's behaviour. Comment was sought from other former Chief Justice Murray Gleeson, but nothing.
I mean, what are they supposed to say?
I don't know.
And then the question will be, well, why the hell didn't you say something?
I know.
You know what I mean?
I know. So then I thought, okay, have we had any changes affected by this situation?
That's a good question.
Yes. So Dr. Tom, who conducted the inquiry, said her recommendations related to how staff interacted with members of the High Court bench. Among those recommendations was that the court should make clear to associates the confidentiality requirements did not extend to social functions. Now, I can tell you that the actions which the High Court said they were adopting and acting upon were developing a supplementary HR policy relevant to associates, reviewing the induction it provides to associates to make sure it covers material directly relevant to their role, to identify an appropriate person to form a closer working relationship with associates who would check in and provide advice and mentoring.
This sounds a lot like we're telling the associates as opposed to we're telling those appointed to the judiciary. And I'm not being critical of the judiciary, obviously, but the response to this...
These are the 6 things.
Sorry.
Those 3, they should clarify that the confidentiality requirements relate only to the work of the court. The court should make clear to associates their duties do not extend to an obligation to attend social functions, and the court should consider canvassing current associates to find out more about their experiences while working at the court.
Okay. So they're all focused on the associates and perhaps not as much as they should be on those appointed. And I should say, when I say those appointed, I've been at functions. I've never seen anything untoward by a member of the bench and the fraternity.
No. And I've had nothing but positive experiences myself, but that doesn't take away.
Exactly.
Now, there was some criticism from supporters of Heydon.
Well, as there should be. Well. They're looking at it from the fact that there's been no charges. There's been no formal legal tribunal that have rendered a decision either on balance or beyond reasonable doubt.
And that was the big criticism, that it may have lacked procedural fairness and was conducted by a person who was not a lawyer. So those close to the matter said he was never allowed to cross-examine his accusers or test the veracity of their allegations. He was simply permitted to inspect written allegations and was allowed to provide a response that was considered by the investigator before she reached her decision. No,
you can certainly understand that component of it. I mean, but who would benefit, I guess, of it going to a full hearing, and it didn't end up going to a full hearing.
No, it did not. So another thing that seemed to make some progress was there was a private members bill put forward in October 2020, the Judges' Pensions Amendment, Pension Not Payable for Misconduct Bill of 2020.
Ooh.
So what do you think that was about?
Yeah, well,
they
wanted the ability to reduce or take away the bench's superannuation or pension or whatever they get after retirement.
Yeah.
See that? You could, no, I've got problems.
So this bill was intended to amend the Judges' Pensions Act to provide that a pension is not payable to a retired judge on account of serious misconduct while they were serving as a judge.
Well, there has to be there would have to be an actual finding of serious misconduct, not just allegations, but I couldn't, no.
There was no definition of serious misconduct included in that bill. And the senator who introduced it, Senator Patrick, explained that the bill would operate retrospectively to make sure everyone who needed to be could be held accountable. That, however, lapsed at the end of Parliament, July 2022, without any further progress being made beyond the second reading speech.
Yeah, and again, we've got the separation of powers and free from independence.
There was the introduction of the National Anti-Corruption Commission as an independent Australian government agency to detect, investigate and report on serious or systemic corrupt conduct in the Australian government public sector. Now, this came into effect in July 2023. After the report and Justice Keifel's comments, there were suggestions that there needed to be oversight of the judiciary, that there needed to be some kind of mechanism. All of that was discussed. What we have is this National Anti-Corruption Commission, which was also needed for a number of other reasons. It's not just for this. So that is something tangible that we can see as a...
It's interesting because we don't have any judicial... Well, I should clarify. There is a way to make a complaint against a judge here in Queensland. There's no oversight body. In Canada, they have the National Judicial Council, which you can, and a judge can be removed. But we don't have that here in Queensland.
No.
And there is a way. I mean, if you have a problem that's legitimate and the bar is met, you can make a complaint to the Chief Magistrate's office, for instance, or there are avenues.
Yeah. Well, I mean, I don't know. That's still fairly new, July 2023. Yeah. So there hasn't been a lot of time yet for its productivity or its outcomes to be fully appreciated.
Right.
So I guess we'll wait and see. But while I'm doing all of this reading, I go down rabbit holes.
Yeah.
And I found he's back in the media in May of this year. This is Dyson Hayden. Yeah, very recent. So he has self-published a textbook, a law textbook called Heydon on Contract, Particular Contracts. Now, he had originally published a previous work on contract law, and the publisher of that was Thomson Reuters, or however you say that. And they reviewed their relationship with the former judge after the investigation became public in 2020, and that book is no longer on their website. So he self-published this new one. It's published by Sumner Publications, which is a business name registered to him. So I was like, okay, fine, he can write a textbook, no problem. I'm not sure who's going to can't.
I mean, buy it.
Well, apparently, according to a lot of members of the legal fraternity, everyone will buy it and everyone will benefit because he is such a learned, intellectual expert on contract law.
Offer and acceptance.
So I feel a bit sad because the foreword is written by former High Court Judge Justice Kirby, and he calls the book an important work of legal exposition, an intellectual masterpiece, and a magnum opus.
Wow.
Be that as it may, I don't understand how he's suddenly back in the legal community's good books after Chief Justice Keifel said that the women who said he sexually harassed them were believed.
Yeah, I mean, it's a pretty powerful forward to have. I mean, Kirby is one of the most well-known jurists in this country, and for human rights type.
And an amazing jurist.
Yes, there are some that think that he's amazing. There are some that think that there's a bit of judicial activism in his decisions, but he was always progressive.
I don't have a problem with judicial activism on occasion.
I'm a little bit different on
we
that.
Might need to talk about that
we
one
might
day.
need to have a talk about that, Liz.
So putting that aside,
Yes.
The book has been popping up in barristers' chambers and law firms around the country.
Not mine, for the record.
Heydon himself was recently invited to Friday after work drinks at the federal court, something which he has not done, I don't think, in more recent times.
I mean, that's a pretty powerful statement in and of itself to be welcomed to the federal court. But I guess they are coming back to the reality is that there were no charges and there was no findings.
And in August 2025, he has been asked to speak at the Samuel Griffith Society's annual conference. So current High Court Judge Simon Stewart will be speaking there, as will former Western Australian Premier Richard Court. So I just question what kind of message all of that sends if we can celebrate and laud this person who, yes, no criminal conviction, no commission finding, but an independent inquiry that has been accepted by the High Court that resulted in an historic compensation payout to these women. I mean, what's the point of all of that if it's not to have any longevity, any bearing on this situation?
No, I agree. And I think, and whether you agree with me or whether you don't, if there was a criminal complaint that was filed and it came to fruition and was disposed of somehow, either with a finding of guilt, because it sounds like there was quite a bit of evidence.
Yes.
That would have changed everything.
Yeah.
And I always say, if something has happened and no charges are filed, well, there is that component to it.
But it also bothers me that that these very high level justices and professionals believe these women, and yet there is no tangible consequence for the person they are accusing.
But what should be the consequence, though, Liz, when they're not in front of a court? They can't cross-examine these
but even
victims.
If that's...
They can't test the evidence, and that's both on balance and beyond reasonable doubt.
Okay. But because I don't think that's even the answer. Like, it takes me back to the Lazarus case in Sydney, which was...
Yes, I know all about that.
In court. It was a finding of guilt, and his conviction was quashed, even though the judge said to the victim, I accept you did not consent, but I also accept that he thought you were. So it doesn't matter if these women are being believed. The way the system has been, and I worry that it hasn't changed enough, we can believe these women. We can believe their allegations.
Oh, certainly.
And it still doesn't have tangible outcomes, whether it's in a court or not.
But I mean, what is the tangible outcome that you're looking for?
Well, Lazarus should have stayed in prison.
Yeah, but starters. Okay, all right.
But if this was another person, not a former High Court judge, would they have commenced proceedings? 6 complainants.
They should have.
And so why didn't they? Like, this is the tangible outcome that I wonder.
Like, they should have, one of the 6 should have filed a formal complaint.
It got referred.
Well, what does referred mean, though? Like, you go to the police station, you say, this person did X, Y, and Z to me. We start an investigation, irrespective of them being a former High Court judge. And you go down the traditional route of questioning individuals.
But the DPP referred it for investigation and nothing happened.
Yeah, I don't know what the referral process is.
But
and you need a complainant. You need a complainant.
They had 6.
Yeah, but did the complainants provide police reports?
Well, I don't know that they're going to go on their own. You think about the statistics of victims of sex offences.
Yes.
The percentage who actually report is so low.
No, I know. We need to get that up, is what I'm saying.
So why are we putting the onus on these 6 women who had the courage to come forward and tell somebody their story, and it is believed by the highest judge in the land?
Without a trial.
So then the onus is still on them to start the prosecution? It got referred.
No. You need a complainant to start it. No.
I don't understand how they're not complainants.
Because they didn't give a formal police statement.
But But why is the onus on them to get that process started? They made the complaint. They told people in authority. Those people in authority then said, okay, let's refer this for investigation. And that was never done. So why are we saying it's their fault?
I'm not saying it's their fault. I'm saying that if we want the tangible results that we're talking about right now, heatedly, I might add, but you need to complain it. They needed to go to police themselves, file a statement, levy an allegation, and commence proceedings.
Okay.
I just don't know what. I can guarantee you if that one of them had did that, an investigation was formed. There are people that are charged in this state for less allegations that have to go to court. And I can tell you that if he was found guilty in a criminal court, he would not be standing up at whatever he's standing up at down the track for a speech because he'd be in prison.
Well, you can go and read an article
Sure.
that Rachel Collins wrote in response to this information about his new textbook. So it's dated 28th of June, 2025 in the Sydney Morning Herald.
All right.
And she is commenting that she is upset by this acceptance of him. She said, with growing concern, I've watched efforts to recast him as a victim and downplay what remains one of the most damaging stains on the High Court and the integrity of Australian legal conservatism. She talks about the fact that the judge-associate relationship is unlike any other. He had unchecked authority over us and the power to shape or obliterate our careers.
No, I accept that.
And I just think, they did what they could.
And I should say that it could be the case, Liz, and I don't know, but it could be the case that they did go and file a police report and then nothing was done. So if that's the case to all 6 of them, I apologize.
Yeah, I guess we don't know.
I don't know, and I shouldn't have assumed that one was and one wasn't done. So
anyway, if we come back to sexual harassment in the legal profession, I think more does need to be done, but there has been a recent report, the National Action Plan to Reduce Sexual Harassment in the Legal Profession, led to the release late last year of a public leadership statement on sexual harassment and discrimination. And there's now a national model framework for addressing sexual harassment for the Australian legal profession. So there's definitely progress being made there. In relation to the complaint in the Northern Territory that we started with, the associate said, or the woman said, when she was an associate, she complained to another judicial officer. She was told to speak directly to the judge involved about her concerns and to report back if the harassment got worse. The judicial officer said another option would be to swap the complainant with a male associate.
Yeah, that's horseshit.
Isn't it?
It's just as amount of horseshit as a government decision to try and shuffle that under the carpet.
So she said it wasn't until 2020 when she saw the reports about Justice Hayden that she believed it might be possible to take action here. But anyway, the Northern Territory Anti-Discrimination Commission said it is in the public interest that judges and public officials are not seen as above the law and are held to account when there are serious allegations of sexual harassment and sexual discrimination made against them. And so they are going to proceed with their investigation. What else? The lawyer who represented the women in the Heydon case is also involved in this Northern Territory case. He slammed the Northern Territory government's attempt to block access to justice as prehistoric. Someone forgot to tell the Northern Territory government that we live in the 21st century, he said.
And how dare they try and sweep it under the carpet?
I know. He said, adding further insult was the fact that women who suffer sexual harassment in the Northern Territory are already treated as second-class citizens. Under Northern Territory law, a woman who suffers serious injury and loses her legal career can only be compensated a maximum of $60,000, the lowest in the country. That amount has remained unchanged since the 1990s. Under the Federal Sexual Discrimination Act, there is no cap on damages.
Yeah.
So there's incremental progress, but I read all of this in 2025 and I think, we need to do better.
Yeah, we certainly do. And I mean, there has to be consequences and we just need to find a way to get them out, I guess.
I know. You're right. I don't know what I'm looking for when I talk about outcomes in that Heydon case. And I'm glad they got the compensation, but they did not get the life that they had planned and that they embarked on when they started as his associate.
And I think of the imbalance. So I haven't lost sight of that fact. And I mean, you were an associate. You know that that is a powerful position. You know that you're in a privileged position. So obviously these associates were put in untenable positions with respect to that.
Yeah. I do want to just confirm again how lucky I was.
Oh, I'm
to
jealous
have the judge that I had.
Absolutely.
And I don't know if you're familiar with Bri Lee. She wrote a book called Eggshell Skull Rule about sexual assault. She was a judge's associate a little after me, but similar vintage. And her experience as an associate in that book was polar opposite to mine. And I read her book and I felt so sad for her as well that, I look back at that time and think, I was so lucky.
Yeah.
And other people did not have that same experience. And
me.
And that is sad to me. So, I would still say to anyone, getting a job as a judge's associate
It'd be awesome. I'd love to do it now. I'd love to go back and do it now.
Yeah.
Can I say, and I know I've mentioned, the legal stuff about, on balance and there's been no finding and whatnot. I say that, but at the same token, I can tell you that I'm glad he didn't ask me to write a foreword in his book because there's no way in hell I would have written one.
Yeah, I would not either. I would not buy the book, would not recommend it, would not set it. No.
So there you go.
So that's that.
Wow, it's pretty intense. Like
it really is.
It's unfortunate, it's avoidable, and it's preventable. And we've got more to do in this.
Yeah, we really do. So
thank you very much. Thank you.
Right.
Thank you so much.
No worries.
Thank you for listening to the episode. If you enjoyed it, please rate and review the podcast. If you're interested in clips, check out @Justice Matters Pod on TikTok and Instagram.